Good morning. Welcome everyone to this presentation on immigration. Today we're going to be talking specifically about U.S. visa options for international technology professors, entrepreneurs, and investors. I put this QR code here because our firm is always providing updates on breaking news. We do training videos and things like that. So if you want to follow us on LinkedIn, I would encourage you to do so. The other thing I would say is this presentation is designed to go for 1 hour, and then after that, I will answer questions for up to a half hour. So if you have questions, put those in the chat, and I will get to those at the end of the meeting. I would encourage you not to ask very personal questions in the chat. I will also be providing my contact information, so you're welcome to reach out to me separately with personal questions. But if you have general questions that would be helpful to you and potentially others, feel free to put those in the chat and I will get to those at the end. And if everybody would stay on mute, I would greatly appreciate it. Let's go ahead and get started. Just to briefly introduce myself and my law firm, my name is Chad Graham. I have been practicing business immigration specifically for 16 years. I work with individuals, I work with companies of all sizes, from startups all the way to publicly traded companies. Our clients tend to operate in sort of a concentration of fields, although we do have people in all sorts of different areas and different fields, but the concentration tends to be within the technology, science, medical, and finance industries. My law firm, I started with my partner, Sam Adair, 13 years ago. I work at the organizational level of the firm and advise clients on strategy and policies and options that they might have available to them. This is where I brag for just a second about the firm. We work with the difference between us or the way we try to differentiate ourselves in the market is really with the customer experience. And so that shows up in our Google reviews, and don't worry, I'm not going to read these all to you, but we really focus on the individual and less on the process. And so we enjoy working with people and seeing the things that you have going on and how we might be able to help you achieve those career goals. So the agenda here is we're going to start by talking about non-immigrant visa options. And what we mean by that, these are typically your work visas. The reason they're called non-immigrant is because they're typically a temporary status. So you can stay here for a certain period of time, then the idea is that you would return to your home country. Now, one of the things that you'll hear during this presentation quite a bit is dual intent, meaning you have the intention of coming here as a non-immigrant and working for a specified period of time, but you also want to stay in the United States on a long-term basis and go through the immigrant visa process. So you can there are some statuses that allow you to have that dual intent of being a non-immigrant and an immigrant at the same time. There are other statuses that don't allow that, and that can cause some complications. And like I said, we'll dig into that a little bit. But we'll start with the work visa or the non-immigrant visa options, and then we'll talk through the immigrant visa, also known as the green card process. Okay, so let's start with the work visas. Again, if you have questions, put those in the chat and I will get to those at the end of the presentation. The first visa I like to talk about is the H-1B visa. This is sort of the most common one. If you don't know a lot about business immigration, you've probably still heard of an H-1B visa because it's often in the news. It's the one that people talk about, and I'll explain why that is. The H-1B visa is for people who are basically your professionals, people that are in a position that require at least a bachelor's degree. Now, sometimes we have people that are, in a field that doesn't require a bachelor's degree, but they have a bachelor's degree, but that doesn't qualify. The government has a specific list of occupations and what those occupations require, and the government database has to indicate that position requires a bachelor's degree. So again, these are typically your professional level types of positions. So the H-1B is subject to an annual limit of 85,000 every year. And the news, what has been in the news is how many people are applying. In years past, that 85,000 would go for a period of time throughout the year, and then eventually it would be used up and there would be no more H-1Bs available. Well, now the demand is so high that during that first week in early March, when the cap opens up, the government, what's called U.S. Citizenship and Immigration Services, or USCIS, always receives more than the 85,000. So then what happens is they conduct a random lottery to select who is going to be picked for this year. And so for this year, there were about 781,000 registrations filed for those 85,000 slots. But what happens is a lot of people are filing duplicate applications, meaning they're filing an H-1B with their current employer, and then a different employer that if they get an H-1B, then they'll hire on with them. There are some people that are filing 4 and 5 of these applications. There were a lot of duplicates. A lot of cases are rejected because they're not filed properly, or they're withdrawn because the person no longer needs them. So what happens is USCIS selects more than the 85,000, anticipating that some of those cases will not be selected in the lottery. In this case, it did an initial round and selected 110,791. Very specific number. I don't know how they came to that exactly, but they figured that would be enough to meet the 85,000. It actually wasn't even close to enough. So they did a second round just last month of another over 77,000 selections, so 188,000 total. So when the H-1B lottery first happened, we felt down because it seemed like the chances of selection were really low, between 10 and 15%. But it actually sort of ballooned back up with the second round to more of a 24% chance of selection. So still not a great chance, but certainly better than it was earlier in April. Now, the other thing I want to point out here is there's a difference between a regular H-1B cap and the advanced degree cap. Those who have an advanced U.S. degree, so think master's, PhD, from a U.S. institution, actually go into a separate lottery. So that 85,000 is broken down into 65,000 for the regular, 20,000 for the advanced degree. So USCIS runs that advanced degree lottery first, and anybody who's not selected in that lottery then goes into the regular lottery of 65,000. So people who qualify for the advanced degree cap actually have a better chance of selection. I would say this year they were sort of between 30 and 35% chance of selection. So if you have an advanced U.S. degree, your chances of getting an H-1B are better than those who don't. These next couple of bullets are just what the timing looks like. The lottery opens in March. Like I said, they give us a 1 week or a 5-day filing window. So we prepare everything ahead of time. It's an online registration process now, and then they run that lottery. And if you're selected, you file. If your case is selected and approved, eventually your H-1B would start on October 1st, which is the beginning of the new fiscal year. So if you were selected this year, then your H-1B is likely ready to start on October 1st. Let's see, a couple of things I want to point out here before we go to the next slide. There is a labor condition application, or an LCA, that goes with an H-1B. And this is one of the government regulations that run with H-1Bs, is that the company has to pay at least a minimum salary for that region and for that industry. And every year they do salary surveys to determine what sort of the median or mean salary is, and then they require employers to pay at least that amount to foreign workers that they sponsor for an H-1B. And the last thing is the H-1B is good for an initial period of 3 years, followed by a 3-year extension, so 6 years total. And this is what I meant by having a non-immigrant visa, because the intention is that you would be here for 6 years and then return to your home country. However, the H-1B is a dual intent status, and a lot of people in H-1B intend to go through the green card process and you can do the green card process while you're in H-1B status. And the magic of the H-1B, and the reason a lot of people like it, is because once you get to the end of that 6 years, as long as you have started the green card process and gotten to a certain point, you can extend your H-1B beyond the 6 years and really almost indefinitely until you get the green card. So we have some people here, and I'll explain why this takes so long, but where the green card process, depending on the country they come from, typically India and China, takes a really long time. But the nice thing about the H-1B is they can stay here, they can continue working and have their H-1B status while they're going through the green card process, even if it takes 15 or 20 years. I have a slide at the end that we talk about processing times. And the other thing I should tell you is that I will make these slides available to you. We'll send out an email at the end of this presentation with the slides and a copy of this recording as well. So don't feel like you need to be taking notes, but I will send you these things that you can refer back to at the end. The one other thing I do want to talk about before we move on to the next type of work visa is that an H-1B is employer specific. So a lot of times people have questions about, can I sponsor myself for a work permit or for a certain immigration benefit? There are some immigration benefits where you can. H-1B is not one of them. It requires an employer to sponsor you. So you have to have a US company that says, yes, we will sponsor your H-1B, we will pay the government fees, we will pay that required salary, and they make certain attestations. The nice thing about the H-1B, even though it is tied to a specific employer, is it is transferable. So if you have one employer, you work with them for 2 years, then you decide you want to change to a different company, as long as that new company will transfer your H-1B, then you can transfer that and continue working and continue using those 6 years of eligibility. Okay, the next visa I want to talk about that comes up a lot is the L1. The L1 is for individuals who work for a company outside of the United States, and that company also has a US entity, and they want to transfer into the US entity. So the way you qualify for an L1 is by having at least 1 year with that company outside of the United States, and then transferring into the United States. And then the other piece of it is that you have to either be an executive or a manager, which is what they call an L1A, or you have to have some sort of specialized knowledge, which is an L1B. So an L1A, executive or manager, you can anticipate what the definition of a manager is. If you have direct reports, and they're not sort of like frontline direct reports, but degreed professionals, let's say, that is sort of the traditional definition of a manager. If you don't have direct reports, you may still be able to qualify as an L1A, but we would have to demonstrate that you are a functional manager, meaning that you manage an essential function of the company. And so we would look at things like budgets, we would look at the department and the importance of the department within the overall scope of the company, things like that. It's a little bit more of a difficult argument to make. If you have direct reports, it's pretty clear that you're a manager. If not, then proving functional manager is a little more difficult, but certainly possible. Then an L1B, on the other hand, so if you're not a manager, but you have some sort of advanced or unique knowledge, that can be a skill set that is not readily available in the United States. It can be based on some proprietary technology or tools that your company has, things like that show that this isn't a skill that's readily available in the United States that companies here can hire for. Therefore, the company needs to transfer you to the United States to continue to do that work. Now, the difference between L1A and L1B is that L1A is valid for up to 7 years, whereas L1B is only valid up to 5 years. So you get a 3-year approval, and then if you're L1A, you get 2 extensions for 2 years each, or if you're L1B, you get 1 extension for 2 years. Now, the difference here between L1, or one of the differences, I should say, between L1 and H1B is that L1 cannot be extended beyond that limit, that 7 or that 5-year limit, unlike an H1B. So a lot of times people who come here as an L1, we will encourage companies to change them to H1B, especially if they are from one of those countries where the green card takes longer. I mentioned specifically India and China, because it is anticipated that their green card process will take longer than the 5 or the 7 years in L1 status. We want to get them into an H1B so they can extend that indefinitely while they go through the green card process. One of the areas an L1 comes up specifically within this group is a new office L. A lot of times we have individuals who have companies in their home country, and they have desires to set up an entity within the United States and start operating in the United States. So how do they do that? Well, they need to set up their company here, form an LLC or an S Corp or something like that, have physical premises, whether it's a lease or a building purchase, someplace where the company can carry on operations. And then what we do is we file what's called a new office L. And essentially we're telling USCIS, US Citizenship and Immigration Services, that this person is coming to establish a new company. And the expectations for that initial application are fairly low, because obviously this is a new company. It doesn't really have operations yet, doesn't have employees or contracts in place. And so what USCIS says is, okay, we'll give you a year. So let the person come over here, give us a business plan on, what you're planning to do. And the business plan is really key to this. And then at the end of that year, we have to file an extension and say, here's what the company said they were going to do, and here's what they actually did. And you don't have to do it exactly as you say, but as long as the company is operational, it looks like it's going to be financially viable. It's really good if you can have staffing at that point, even just 2 to 3 employees. Then that shows the government that you have a viable business, and then they would give you that 3-year extension. And the nice thing about that is once you set up the U.S. entity, if you're doing it for yourself, is then if you have other employees at your location outside of the United States in your home country, you can then transfer more individuals in L1 status to your company. So this is one that comes up a lot. New office L1. Like I said, it's fairly straightforward initially, but to get the extension, that's where the difficulty comes in. So if you have a company in your home country and you want to set up in the United States, this is probably a good option for you. Okay, so this next visa is it's called an O1, the Extraordinary Ability Visa, and it is sort of what it sounds like. Essentially, what we're saying here, to demonstrate that somebody qualifies for O1, we have to prove that they are at the very top of their field, that they have been recognized in their industry, and this is specifically within the fields of science, education, business, or athletics. And what we're showing is, so typically the people within the first two, the sciences, education, and to some level technology, typically those individuals have a PhD. It's not a requirement for O1 to have a PhD. That comes up a lot. It's not a requirement, but typically the people that qualify within those first 2 areas do have a PhD, and I'll explain to you on the next slide why that is. Those within business or athletics often don't have a PhD, and again, it's not required. They can be very successful. It's just within the sciences and the education fields, those that have a PhD have had the opportunity to do some of these things that are required. So what we have to show the government to qualify is that they have met at least 3 out of 8 criteria to demonstrate that they are extraordinary. The other way to do this is if the person has won a major prize, like a Nobel Prize or something like that, where it's a major prize, it's very well known, or if they're in athletics that they won the Stanley Cup with their team or something like that. But typically, people don't have those kinds of really high level prizes, and so the government set up sort of a framework of, okay, well, here are the 8 criteria that we think are important to show that someone demonstrates that they've risen to the top of their field. If you can meet at least 3 of them, then we'll agree that the person qualifies. The problem here is this is sort of a framework, like I said, they're not bright line rules. And so what will happen is if you say, well, I think I might qualify, we'll go through and look at your CV. We'll have you answer some questions to let you know what we think the strength of your case is. We file these cases all the time, and so we have a sense for what the government's looking for. And actually, the framework is always kind of shifting. So what they were looking for last year may be different than what they're looking for this year a little bit. But we have a pretty good grasp on that, and we can let you know what the strength of your case is. The other thing I should say is with an O1, this does require company sponsorship. This is not a self-sponsor option. So if you're looking at an O1, you do need a company that has hired you or plans to hire you and will sponsor your O1 for you. Okay, so the 8 areas, and like I said, we have to qualify for at least 3, are original contributions to the field. So these are things that you've done that maybe nobody else has done, or you've innovated on within your field. Patents are a great example of this, because obviously you have to prove novelty to get a patent. Another thing we see a lot is white papers. We'll ask you for letters of reference from other people in the field who are highly regarded, who can say, yes, this person has really done made some original contributions to the field. So that's how we prove that first criterion. And so the second one, publication citations, this is really where the PhD comes in handy. People who have a PhD often publish. And so we like to see at least 10 publications if possible, at least half where you're the first author. That makes it a pretty strong category. Again, this is where the bright line rule comes in, because there isn't one. You might think, well, I've published 2 articles, that should be good, but the government will look at it and say, that's not that good. Two isn't really enough. They don't say, well, you have to have at least 5 or whatever the number is. It's sort of a on balance test. So, are you the first author? Have they been cited a lot? There's a lot of factors that go into it. The third criterion is articles written about you by others. So if you're in business or you're in athletics and you've been written up because you've had some major breakthroughs, those types of publications go a long way. Or even if you're in a science or medical field and you've done some research and others have written about it or sort of piggybacked on the work that you did, that can be good evidence as well. Major awards like we talked about. So I mentioned the Nobel Peace Prize. That's not, if you have one, great. That's not really what we're talking about here. These are things like you've won major grants, you've had competitions that you've won, other major awards like that show that you've made some significant accomplishments in your field. Memberships in organizations that require accomplishment to become a member. Employed with organizations with strong reputations. So if we worked with a publicly traded company, for example, that's a great example, or other like a university, something like that, strong organizations. If you've received a high salary or remuneration, the way we look at this is we look at where you live and the field that you're in and figure out what the government anticipates the salary will be. And then if you're at least 25% above that, then we could make the argument that you command a high salary as compared to your field. And then the last is the judge or the reviewer of the work of others. So this can be peer reviews if you've done a lot of those, or if you've been on a panel of judges for conference posters or things like that, that can count as a judge or reviewer of the work of others. The duration is 3 years followed by 1-year extensions. And so the initial 3 years is great. Then the 1-year extensions can get tedious over time. But the nice thing about the O1 is that it is what we call a quasi dual intent status, meaning that if you're on O1, you can also move into the green card process and it doesn't create a conflict of intent. And the nice thing about O1 is it goes very smoothly with a specific green card process that is more streamlined and a little bit faster. So the O1 is great from a number of standpoints. And one of them is sort of opening the doors to the green card process in a better way. Okay, I'm going to take a breath here before we get into the J1. I'd encourage everybody to keep their phones on mute if you can. If you have questions, put them in the chat and I will get to those at the end of the presentation. The next visa I want to talk about here is a J1. It's a cultural exchange visa. And this one is often overlooked because it comes with a number of restrictions, but depending on your circumstances, it can be a really good option. Typically, well, I shouldn't say this. J1 is anticipated as sort of a temporary cultural exchange. So people come to the United States, they gain some sort of experience, and then they go back to their home country. And the idea is that they then take that experience back to their home country and it benefits their home country. There are a whole bunch of different fields for J1. The ones that I focus on, because they tend to be most relevant with this group, are the intern and trainee categories. And the way a J1 works is, let's say you have a company in the United States that says they want to bring you here, they want you to do some training or some work, something like that. Then we would go and find a J1 sponsor, and there's one that we work with specifically that's pre-approved by the government. And they would look and make sure that you qualify. And if you do, then they will sponsor your J1. And so you have your employer, you have your J1 sponsor, and they sort of work together to get you that J1 status. You would get your approval, you would go to US consular post in your home country, and you would apply for a J1 visa. Then you would enter. J1s are typically valid for a 1-year period of time. They can also be extended, but not indefinitely. A J1 is a pure non-immigrant intent. So when we talked before about H1B being a dual intent, you could go to the green card. seamlessly. A J1 is not a dual intent status. That's not to say that if you get a J1, you can never apply for a green card, but it's just, you can't go directly from a J1 to a green card simultaneously. It creates a conflict of intent. The other sort of restriction with the J1 is it often carries a 2-year home residency requirement. As I said before, it's intended to be a cultural exchange visa. So you come here, you go back to your home country for at least 2 years. And so depending on the country that you're from, there's a specific country list, skills list, where depending on what your home country needs, they might say, well, if they're coming here to do medical, we really need that in our home country. And so we want them coming home afterwards. And so then this 2-year home residency would attach. So that's something that we would look at ahead of time to let you know, hey, this is something that's going to be part of your J1 stay. If that does happen, there are ways to get waivers to those 2-year home residency requirements, and to get your home country to agree to not enforce it, and then you can actually stay in the United States. So there are ways around it, but it's something to definitely be aware of. So interns, the intern category within J1 are those who are currently students or have graduated within the last 12 months. And so the idea is they're coming to the United States to get the training they need to embark on their career. A trainee is somebody who has at least 5 years of experience. Oh, excuse me. 5 years of experience, and then they're coming to train in some sort of a specific field. So like I said, there's a whole bunch of fields for J1. These are the two that we tend to see the most. Okay, now, one of the things that is of interest to people is, how do I sponsor myself if I don't have an offer from a US company and I just want to come to the United States? How do I do that? The options are fairly limited. It's typically as an investor. And so this is the first sort of I would call it self-sponsorship option, is an E2. Now, the first thing is we have to make sure that you're from a treaty country. There's a whole list, and this link here, you can check it out if you want to see if your country's on there. But that list will show for E1 and E2 whether your country is listed. If your country is listed, that means that you are from a treaty country and you can qualify for an E1 or an E2. Now, the reason I'm not talking about E1 is because it's for people who are already doing trade with the United States, which often with this group is not the case. E2 is for those who are looking to make an investment within the United States, typically with a startup company that either they're starting their own or they're looking to purchase an existing business and grow it or continue to carry on operations. These, I'm going to show you on the next slide what these definitions mean, but the question that always comes up is, well, how much do I have to invest? What's the bright line rule? And as always, it seems like within immigration, there's not a bright line rule, unfortunately. The amount that I typically say is a good rule of thumb is at least 40,000 US dollars. Showing that kind of an investment shows a commitment to the endeavor. That doesn't mean to say that if you invest 25,000 that you can't do it. It's a more difficult argument that we would need to make that you have made enough of an investment to really make this business an operational, that it's going to be able to be a viable company. You need to own at least 50% of the company, and then like a J1, an E2 is a pure non-immigrant intent status. Again, that's not to say that you can't apply for a green card if you get an E2, but it's just more of a process to be able to get you there. Okay, now here, I'm going to go through some of the definitions for E2. So the investment means money at risk. What they don't want to see is that you've put money in a bank account and say, well, I'm going to invest this someday. They want to see that the money is actually at risk. And you also have to demonstrate the source of the funds. They're looking for to make sure that it's from any legitimate source. I don't want to talk about what would be illegitimate, but if the money comes from an illegitimate source, that would not count. It needs to be money that you've earned. The investment needs to be substantial. So, like I said, there's not a specific rule on how much it needs to be, but they want to see the kinds of things that you're buying are the kinds of things that one would anticipate are required to start a company. So you're buying office supplies, you're renting an office space, you have marketing materials, You've set up a website, those kinds of things. Those are the things you're spending money on. The other thing is if you buy an existing business, that's a great investment. Obviously, the other thing I would say is if you're buying an existing business, it should be a business that has positive profitability and has at least 3 to 4 employees. But if you do that, that's great evidence that sort of meets all of these definitions. In terms of marginal, what they want to see is that it's an investment that's going to result in something beneficial. As we move forward here, you'll see with a lot of these options, they want to see that there are going to be hires within the United States. That's one of the things that the United States has set up with these immigration options is they want investor dollars coming into the country to create jobs. And so if your business is looking like it's going to be creating jobs, then you have a greater chance of success. This is where business plans come in and can be so critical to show how you're going to get to that level, how many people you think you're going to be hiring, and that sort of thing. Real and operational just means that it's, you're not just starting sort of a think tank or an R&D company that's not going to be producing something. They want to see that you're producing, that you have contracts, that you're providing services, and that there are real business operations that are going to be doing some sort of product or service. And then we already talked about non-immigrant intent. So that's an E2. This is the last non-immigrant option that we're going to talk about here. And this is actually not a status. It's called actually a parole. And basically what it is it enables the person to come into the United States as an international entrepreneur. This was created under the Obama administration to, again, encourage more investment within the United States. Now, there are some differences here between the E2 and the International Entrepreneur Rule. The main one is with an E2, it's your investment, it's your money that you're putting in. With the International Entrepreneur Rule, typically it's somebody else's money you're putting in here. And what they want to see is that this is what they call a qualified investor. So it's somebody who has a track record of success with these types of investments in these types of businesses. If you have a venture fund that's investing, then that's very good evidence because probably they have a track record that they can demonstrate where they've made these types of investments successfully in the past. Where we do run into problems on this one is where it's an individual who's making the investment. If that individual has a track record of success as an investor, that can work. They can be deemed a qualified investor. But if it's somebody who hasn't, and maybe this is their first, or maybe they've only done 1 or 2, and it's still sort of in limbo, the previous projects are in limbo, and we don't know whether they've been successful, this can be difficult. Now, the nice thing about the International Entrepreneur Rule, unlike most other areas of immigration, is they actually do provide a bright line amount. It started at $250,000 US dollars investment, and it's subject to inflation. And so every year, a couple of years, they move the amount up. Right now, it's sitting about 270,000. And then the other thing is if it's a government-funded project, then the amount is 110,000. So it's less to encourage that sort of government involvement type investment. But again, what they're looking for here is that there's going to be a significant benefit to the public, that it's going to be that there's an opportunity for substantial growth. And again, you're going to see job creation. This is going to be creating jobs. They love to see that. You have to own at least 10% of the business to qualify for this. Again, you don't have to be the investor, but you do have to be involved in running the company operations. So this is not really for passive investors. Okay, so with that, we're gonna switch a little bit to shift gears here to the green card process. Again, I'll reiterate, these slides will be made available to you as well as this recording. So we will email those out to you at the end of the presentation. If you have questions, please put those in the chat. I encourage you not to put very specific personal questions. For those, you can contact me. I'll provide my contact information at the end. And like I said, we'll be sending you an email as well. So you'll have my contact information. But put those questions in the chat and I will get to those at the end of this presentation. Okay, so let's talk a little bit about the green card process. Typically, the green card process for those within the employment-based sector is a three-part process. The perm labor certification is the first step, I-140 is the second step, and then I-485 is the third step. Like I said, this is the typical process. There are other things, other ways as well that I'll explain. This process is employer sponsored. So normally when people go through the green card process, it requires a US company to sponsor them. The perm labor certification is the first step. And that really is, so most of what I talk about here is US Citizenship and Immigration Services, or USCIS. That's the government body that we file for most immigration benefits through. The perm labor certification, on the other hand, is actually through the Department of Labor. And what their goal is to protect US workers and make sure that US workers are not being displaced. And so what the employer has to do is to demonstrate that they have recruited for this position, they have tried to find a US worker, have been unable to do that, and therefore are hiring this individual from another country. The Department of Labor does not collect filing fees like USCIS does. Again, they are just there to make sure that the company went through the proper testing of the market to demonstrate that they are not displacing US workers by hiring somebody from another country. This oftentimes you'll hear about preference categories. So EB1, employment-based one, EB2, or EB3. I'm going to show you on the next slide what that means. So I'm not going to get into a lot of detail on what that means right now, but EB 2 and 3 is what we're talking about. So if you go through the perm process, this is the standard process most people go through, you're going to be either EB2 or EB3. There are 140,000 immigrant visas available through the employment-based process every year. More than half of those go through, I would say about 60% of those go through EB2 or EB3. So this is the bulk of the people going through the employment process. This is how they get their green card. It's based on experience that the person gained before they joined the company. Again, the perm process is to make sure that US workers are not being displaced. And so what they want to show is that this person already had the experience, not like the company brought them in and then trained them to do the work, because they're saying if you do that, you should do that for a US worker. I know this sounds very sort of protectionist, but it's something that's been around for a long time. That was established by Congress years and years ago. So it's something that we still have to deal with. Some of the rules are very strange. The company has to do recruitment, so they have to place ads. And one of the things they have to do is they have to place 2 Sunday newspaper ads, which, as you guys know, is not really how companies hire anymore. They do it online, or usually through their website or a job search forum like Indeed.com. So these rules tend to be fairly antiquated, but it's something that we still have to navigate for most people going through the green card process. It's something that I hope will change at some point, but right now these are the rules that we're dealing with. Like the H-1B that I mentioned before, where there's a required wage that has to be paid, it's the same thing with the perm labor certification. The company has to show that this is the wage for this geography and for this type of position. And yes, we are going to be paying at least that amount or more. Okay, let's talk about I-140 for a second. So the I-140, once the perm is approved, right now the perm process is taking about 2 years, year and a half to 2 years. It's a really long process right now. But once that's approved, we move to the I-140. The I-140 is a fairly straightforward process that we file with USCIS. And then once that's approved, we can file the I-485 as long as the person's priority date is current. So this is what I'm going to explain to you on the next slide. People from certain countries so that 140,000 immigrant visas I talked about, no more than 7% can come from any individual country. If more than 7% are coming from that country, the applications, then something we call retrogression starts. Basically, a line starts to form saying, okay, well, there are no more visas available for people from your country for this year, so you're gonna have to wait for next year. Well, then if next year becomes oversubscribed, then it pushes back to a third year. And as more and more people apply, it pushes that line back and makes the line longer. So the I-485 can only be filed once an immigrant visa number is available to you. So if you happen to be fortunate enough to be from a country where there isn't oversubscription, let's say Germany, for example, then you can apply for your green card right away that once your I-140 is approved. So you can file that I-45. If you're from India, where there's a wait, then they say, okay, you have to wait to file your I-45. You're sort of stuck after that I-140 is approved, and that's it. Okay, I'm going to explain to you what I mean by the visa bulletin here. So this is something that comes out every month from the Department of State. And what it shows is it shows these dates here. The priority date is sort of like, you know, when you walk into a store or bakery and you take your number and that marks your place in line, your number 472 or something like that. And you have to wait till they get to your number. That's kind of what a priority date is. And your priority date is the date that the PERM labor certification is filed. Or if you're one of the people that get to skip PERM, which I'll explain in a minute, then it's when the I-140 is filed. So it's kind of like the first step taken toward your green card process. Once that petition is filed, that marks your place in line. So, and then retrogression, like I said, means if there's a wait in your visa category. So let's look here. Let's say that somebody from China in the third preference category files their PERM labor certification today. So today is August 17th of 2023. And if you look at the column here that says China mainland born, and then down to where it says third, that's the third preference category, it has a date of September 1st, 2019. So we can see that that person has roughly about 4 years to wait for a current priority date. So if the PERM labor certification takes 2 years, and then the I-140 takes a few months, by the time we get that I-140 approved, they may have to wait a couple of years. The other thing I will say is this visa bulletin comes out every month, and the dates can tend to jump around a little bit. And September is actually the last month of the government's fiscal year. October is the beginning of the new year. And so sometimes we see these dates shift with the beginning of a new fiscal year. For example, if you look at the first preference category for India, it lists January 1st, 2012. Well, just in August, it was like, I'm trying to remember, I think it was 2022. But anyway, for September, what happened is the government said, okay, we're going to essentially shut off this category. We're moving it all the way back to 2012. I expect that when the October visa bulletin comes out next month, that we'll see that EB1 India date jump back. The reason that's important is because as we talk about the different options available to those from India, they often don't want to, as you can imagine, you don't want to wait 12, 15 years for this. And so what I encourage a lot of people to do is if they think they can qualify for the first preference category, it's worth spending a couple of years trying to get there, because if you can qualify for the first preference category, it can save you potentially 10 years in having to wait for a green card process if you happen to be from India. If you're from another country like China, there's an advantage to EB1, but it's not as significant as it typically is from India. Again, this chart doesn't show that advantage, but typically we're talking about sort of like a 10-year difference. So I'm going to talk about a couple of self-sponsor options for the green card. So these are options where a lot of people say, I don't want to go through an employer, US employer, I want to be able to sponsor myself. So these are the options available to you. Again, the national interest waiver is in the second preference category. So if you're somebody from India, this is probably not a great option for you, even if you think you qualify, because if you qualify for a national interest waiver, it behooves you to work for another year or two to see if you can qualify for the first preference category, because again, I'll go back here, because normally this first preference category for India is about 10 years better than the second preference. So it doesn't really make sense to try and self-sponsor for the second preference category under national interest waiver, because you're going to have to wait 12 years to be able to get your green card. Whereas if you work and get into the first preference category, you could potentially save yourself, 10 years or so of waiting. But for people from other countries, not India, the second preference category is a great option. It's a great way to self-sponsor. And this is how you qualify, these 4 criteria here: substantial merit, national interest, well-positioned, and then on balance, it makes sense to waive the labor certification. So substantial merit, again, what you're going to see is the create jobs. So the work that you're coming into the United States to do under national interest waiver is going to be beneficial to a broad scope of people within the United States. There's not a specific list of fields that qualify, but the ones that I tend to see the most are within medical research, homeland security, renewable energy, education, and finance. Especially right now with the banking system being a little bit vulnerable, things within the financial system are doing really well within this category. Again, we have to show that it's within the national interest of the country. So if you're doing something within the medical field that cures cancer, or I saw a company that's trying to get approval for a new drug to help with Alzheimer's, if you're working with an organization like that, helping the medical system within the country is something that's going to be considered within the national interest. Again, I talked about banking. That's another one that's doing really well right now. The third one is well-positioned. So you can self-sponsor. And so if you are self-sponsoring and there's not a company that you're going to be doing this work with specifically, you're coming in to do this sort of, on your own or as a contractor or something like that, they're going to want to see, well, how are you going to actually carry out this work? So if you have investors that are involved and they're going to give you money to start some sort of an endeavor, then that's good evidence. If you have patents protecting intellectual property that you've developed, if you have contracts, work contracts, where you're going to be producing a product or a service. We get endorsement letters from other people in the field to say, this person has done great work and they're going to continue to do great work. What they don't want to do is approve you for national interest waiver, have you come here and then actually not do anything. They want to make sure that you're going to be actually doing the work and that it is going to be benefiting the country. So that's what well-positioned means. And then the last thing is, on balance, it makes sense to waive the labor certification process. As I said before, most people that go through the second preference category have to go through that perm process that takes 2 years, where there's a company sponsoring, they have to show that U.S. workers aren't being displaced. So the U.S. government is saying, okay, we'll waive that, but we need to really make sure that it makes sense to do that. And one of the best ways to do this is if you are self-employed and you are self-sponsoring, we say, well, there's not a company to sponsor the perm anyway. So on balance, it makes sense to waive the labor certification process. Okay, so the EB1 category, the self-sponsorship option, this is great for anybody, but particularly people from India, so that they don't have to wait for that second or third preference category. This is really the best option. And so, as I showed on the previous slide, national interest waiver, there are some specific requirements. And if you meet that and you don't quite meet the first preference category here, it makes sense to work on some of these things that you'll see in the right column there to see if you can qualify for the first preference category. And even people from China, where it shows about a 4-year difference between the first preference category, or I think it was 3 or 4 years between the first preference category and second and third, it makes sense to work towards some of these additional achievements to get into that first preference category. Or if you happen to be from another country and you already meet this, then that's great. The nice thing about EB1A is that, again, you get to skip that perm labor certification process. So it cuts off 2 years of your anticipated green card process. The other thing that's nice, again, is that you can self-sponsor. It does not require a company to sponsor you for this. You can do this on your own. You'll notice that this slide looks a lot like the O1 slide we talked about before. It's essentially identical. So that's why I said if you qualify for O1, it's a great segue into the green card process, because then you go through this EB1 process and you can get to your green card much faster. So I'll review this again just really quickly. We talked about this on the O1 slide, so I won't spend a lot of time with this, but we're showing that you're nationally or internationally recognized for your work within the fields of science, education, business, or athletics. You've risen to the top of your field. We can demonstrate that with at least 3 of these criteria on the right. If you can prove more, that's great. And if you do qualify for EB1A, you can file that I-140. This EB1A is actually the I-140 part of the process. And you can actually file the third step at the same time, that I-485, as long as you have a current priority date. If you don't have a current priority date and it shows a wait in the visa bulletin, for you, then we would file this I-140, get that approved, and then wait until your priority date's current, and then file the I-485. A question that comes up a lot is, when do I add my family to the process? So let's say you're married and you have a couple of kids and you want to sponsor them for a green card as well. You would file the first two steps, or if you can skip perm, then just the I-140. So you file perm, I-140 for yourself, and then when you get to the I-485, that third step, that's where you add family members. That's where you would add a spouse and children to the process. Another question that comes up is, well, who else can I sponsor? The government, the US government really anticipates, when they say family, they mean a married spouse and children. That married spouse can be sort of traditional marriages, or it can be same-sex marriages. Children can be natural children born to you, or they can be adopted children, as long as those relationships are have been done through the government, through proper channels, and you have proper documentation, then those relationships qualify. Parents, unfortunately, do not qualify as direct dependents, or cousins or aunts or uncles or things like that. So they sort of limit it to what they call your immediate family, your spouse and your children. Okay, these last handful of slides here are really sort of references for you. This one, I'm going to talk about premium processing. What each of these cases has is sort of a standard government processing time, and they're always changing. They're always being updated. Sometimes cases are taking longer to get approved, sometimes they're shorter, and in a lot of cases, there's not a lot you can do, unless the case allows for premium processing. What that means is that you file a request with the government to process your case much faster. You pay an additional fee, which right now is $2,500. It's a big fee. But then the government will approve your case much faster. So on this slide, what you'll see is if it has the PP in green, that means it is eligible for premium processing. If it's red, that means it's not eligible. So an H-1B case, for example, depending on the service center it's filed with, can take anywhere from 6 to 12 months for regular government processing time. If you file it with premium processing, then it's 15 days. The government has 15 days to decide on the case. The decision can be an approval, it can be a denial, or it can be a request for additional evidence. But even if they do request additional evidence, usually they're pretty good about, once you provide that evidence, they're pretty good about getting back and getting an approval within a shorter period of time. So premium processing can be good. It's very expensive, but it can be good in some cases. Like if you look down, for example, at the bottom, the national interest waiver or the EB-1A, those two green card self-sponsorship options we talked about, the normal processing time is 1.5 to 2 years. You know, that obviously takes a really long time. Now, if you're retrogressed and you're not going to be able to file that I-485 anyway, then maybe you don't want to spend the $2,500. But a lot of people want to know what the outcome of their case is going to be. So they're willing to, pay that $2,500 so that they don't have to wait 1.5 years. They can get a decision within, a few weeks to a month or a couple of months and know whether this process is going to work for them or not. Whereas if you look at the O1 toward the top, the government processing time is only a month. So it doesn't really make sense to file with premium processing, even though that case is eligible for premium processing. The one that comes up a lot is, can you premium process a PERM labor certification? Unfortunately, no. That goes to the Department of Labor, not USCIS, so there is no premium processing. If you have to go through PERM, you're going to have to go through the 1.5 to 2 year process without being able to expedite that. This slide here, again, is sort of a reference slide on cost. There are a lot of variables so that there could be a wide range here. Those variables depend on a few things, like, is premium processing available? If so, you can pay it, but it's an additional $2,500. It depends on the law firm fee, how much the law firm you hire charges. It depends on whether you can add dependent family members. So like for an H-1B, for example, you can add a spouse, you can add children. They would actually be H-4. They would be H-4 status. And if you add family members, then there's additional cost for that. Some of these processes, it's recommended to have a business plan, which can cost money. So there's a whole bunch of variables here. So you'll see the type of visa, you'll see a range, and then after that, you'll see what the variables are that govern what's within that range of money. Validity. So here I talk about, I'm showing you how long they're valid for, whether extensions are available, and what the total limit of time is. And then lastly, whether it's a dual intent status or not dual intent. Dual intent, again, as a reminder, means that you can have the intention of being a non-immigrant in one of these work visas while also intending to go through the green card process. So you have the dual intention of being a non-immigrant and an immigrant at the same time, and that's okay. So with that, I'm going to go ahead and get into the chat here and answer some questions for everybody. I would encourage you to, if you do have questions, put them in the chat here. If they are personal questions, feel free to send me a separate note later with your personal question. We don't want personal information being shared here. Okay, the first question says, will the recording be shared with the group? Yes, after this presentation concludes, we will provide a copy of this presentation and a recording as well. So you'll get those, and then you'll also have my contact information and you can reach out to me. Next question asks the same thing. Okay, I'm a certified Salesforce developer with 2 years of experience. The USA is the largest market for Salesforce. Is there a way to self-sponsor my visa or a better way? I would have to take a look at your CV, an updated CV. So feel free to send that to me, and I will take a look to see if you qualify. As we went through, there are a whole bunch of criteria to determine whether somebody is qualified or not. So I need to kind of dig into your background and see what your level of education is, what accomplishments you've had in the field, that sort of thing. As we talked about, the self-sponsor options for the green card are really that national interest waiver or EB1, EB1A, extraordinary ability. So the national interest waiver, again, is that you're doing work within the national, a scope that's in the national interest of the United States. EB1A is to show that you are among the very few top within your field, and that we can demonstrate that. So they're fairly high bars to pass, but I'm always willing to look at a CV and let you know what your chances look like. The next one says, what about if I'm still a PhD student in Ukraine? Okay, so if you're currently a student, one of the options in the United States that we didn't talk about is a student visa. So if you come to the United States as part of a US educational institution, they can actually sponsor you for an F1 visa, and then you would come as a student and continue your studies. The other one that we did talk about that's on here is the J1. So if you're a student, you could come into the United States as an intern. And again, that J1, it's intended that you'll come, do work for a while, and then return to your home country. But that's not always the case. If you do want to stay long-term, that's something that we could look at. Okay, it says E2 again, please. So the E2, just really quickly, and you'll get these slides again, but the E2 is somebody who is looking to invest in a business, either to start up their own company or to buy an existing company. They're going to put in their own money. That money is going to be at risk, and they're going to be creating jobs. They're going to be financially viable, those sorts of things. That's what an E2 is. The next one says, I'm looking into an investor visa, which provides green card by investment. I'm also a tech founder and developing a product to launch and looking to make our company take up a space in Silicon Valley. Okay, so there could be a couple of options here. The green card by investment, so one I didn't talk about is the EB5 visa. I don't talk about that because that doesn't often apply to a large group of people. It's an investment of at least $1 million. Under the Trump administration, that amount was bumped up, I think, to like 1.6 or 1.8 at one point, but that was challenged in court, and it has come back down. But that number fluctuates, but it's typically around $1 million of an investment in an operation in the United States. It's going to create at least 10 jobs, and then the person can qualify. So if you're interested in that, we can talk a little bit more about it. But again, that's for this group, that's typically not what people are looking for. And then on the second one here, looking to make a company in Silicon Valley, if you have a company already in your home country, and you want to set up a US operation, a new Office L can be a good option. So that would be something that we would look at. If you don't have a company in your home country and you're just going to be starting up here in the United States, then an E2 is probably what I'd recommend looking at. We could also look at the International Entrepreneur Rule. It depends what the source of funding is going to be. Okay, so I'm a software engineer from Malaysia. I understand that formal education certificates like a degree matters when it comes to visa application. Would someone who doesn't finish high school but has engineering skills face a lot of challenges in a visa application? Yeah, typically most of these options require at least a degree, a US equivalency of a bachelor's degree. So if you have a bachelor's degree in your home country, then you can get an equivalency here. Now, people who don't have a formal degree but have a lot of experience can actually qualify as an equivalency. And the formula is 3 years of experience to 1 year of education, which I know kind of sounds ridiculous, but essentially we're talking about 12 years of experience within a specific area to be able to qualify for a full bachelor's degree. So it's possible, but we would need to be able to get that degree equivalency based on experience. Okay, and then the next one just says they want to talk. Yeah, feel free to reach out to me with any specific personal questions. I'll be happy to talk with you. Okay, as a Canadian, I'm in the US on a TN visa. What if I apply and get rejected for national interest waiver? Will I have problems in the future applying for a new TN visa? It can. So if you're in a TN, and I didn't talk about this one, but a TN visa is considered a pure non-immigrant intent visa. So if you're at a TN and then you apply for an immigrant visa, that does create a conflict. So it's not to say that it's not possible to do it, but I would caution you to be really careful as you go forward with that. Again, that's something that I would be happy to work through with you, but we would need to be sure that by filing, if you file the national interest waiver, then essentially what you're doing is you're leaving your TN status behind and anticipating that the national interest waiver will be approved and you'll get your green card. If that doesn't get approved, then you can be in trouble and alienate your TN. And then the question is, well, can I just go back to Canada and then come back in on TN? Potentially, yes, but if you've already demonstrated an immigrant intent by filing that national interest waiver, then if you go back and apply for a pure non-immigrant intent status, there's going to be that conflict already there. So that can be a potential issue. So I would say to proceed with caution on that one. Again, I'm happy to work with you. Okay, next question. Once the I-140 is approved, what is the process of transfer time to go to a different company if I am shifting to another company? So if you have an I-140 approved, the nice thing is you've locked in your priority date. So your place in line has already been locked in. If you move to a new company, they'll need to sponsor you for a work visa. And so if you're in H-1B, let's say, for example, they would need to transfer your H-1B, and then the new company would need to agree to file a new perm labor certification and a new I-140 for you. But again, you would be able to keep your earlier priority date. Let's see, once the I-140 is approved, what's the time to get the dates current for green card on EB3 or EB2? So there I would need to know the country of origin. As we talked about with the visa bulletin, your country of birth is the country that you're assigned to for the green card process. If you're from India, EB2 or EB3, I don't have those dates in front of me. And like I said, they fluctuate from month to month, but EB3 India, I believe, was sometime in 2009, going from memory. And EB2 India was sometime in 2011. So it's kind of a long wait, but that's where if you have an H-1B, for example, that's a great way to stay in status as you go through the green card process. Okay, I don't see any other questions, so thank you all for attending. Like I said, you will receive an email with these slides and a copy of the recording. This is my contact information here. You can feel free to reach out directly to me. Connect with us on LinkedIn. I would love to stay in touch. Thanks for attending.